Good evening, everyone. Um, I'm going to go ahead and read this expired protection order of mine because I'm hearing that even the defendant back then is saying that I am doxing her by putting out, and it's called a judgment. And this is the final order in judgment as defined in the Civil Rule 54. As defined in ORC 2505.02 in an entry of judgment as set forth in Civil Rule 53D4E. This is public, folks. This is public to the world. Me putting up the first page is public to the world. All of this. It is not doxing a soul. And I will not be intimidated as such. Some passive-aggressive attacks there and assertions that I didn't take kindly to. Talking about me coercing and cohorting with somebody when I know downright and well that she was before the appeal. She had handed out those transcripts to many people. She put them all over social media after the judge ordered her not to, ordered us both to do this, to not put out any transcripts. She did not comply. She put them up on Facebook, on YouTube, and she spread them around to her friends in a hangout and were conspiring against me. And even one of the people admits it in a recording that she was participating in third-party harassment against me and apologized for it, which I accepted and only am stating as a fact. So I'm going to go ahead and read this. You know why? Because it's my freedom and my right to read it. And I will not be intimidated and be told that I better just leave something alone. I better watch out for myself. She's starting to throw intimidation my way, and it's not going to happen. Now, I've lost a couple of my bottom teeth. I haven't got anything to fix them yet because I haven't wanted to. So I do have a slur. This is Rebecca L. Dean, petitioner versus Brenda Sue Becker. Case number 17-DP-0128. This is in the Common Pleas Court of Clark County, Ohio, Domestic Relations Division, Adult Section. This was filed February 28, 2019 at 9:16 a.m. in the Common Pleas Court, Clark County, Ohio. Decision and final judgment entry. This matter came on before the court on July 27th of February 2019 for a final objection hearing upon the original objection filed on behalf of the respondent, Brenda Becker, on March 20th, 2018, as well as her supplemental objections filed January the 7th, 2019. Present on this day was the petitioner, Rebecca Dean, pro se. Also present was attorney Ed Frazil on behalf of the respondent, Brenda Becker, who was not present and who was excused from these proceedings by the court in its entry filed January 15, 2019. This court has conducted a de novo review of all the prior pleadings and orders filed in the within matter, as well as a transcript of the proceedings which took place over the course of 6 days before the magistrate on June the 19th, 2017, June the 31st, 2017, September 18, 2017, October 25th, 2017, and December 20th, 2017, and March 7th, 2018. So now you can see how long it was, too, since this was just finalized in February of 2019. This court has also reviewed all exhibits which were admitted into the evidence before the magistrate in the court has considered statements made at the final objection hearing within. I did not get to read what her objections were. When she appealed it, they did not let me see the reasons why it was being appealed. But it didn't matter. Okay, now I'm on page 2. By the way of background, on February 16, 2017, Ms. Dean filed a petition for a civil stalking protection order in this court against Ms. Becker. An ex parte temporary order was issued by this court on the same date in favor of Ms. Dean and against Ms. Becker. As mentioned, a final evidentiary hearing took place before the magistrate over the course of 6 days as set forth herein before. On March 13, 2018, the court issued a final civil stalking protection order in favor of Ms. Dean and against Ms. Becker, which would remain in effect until February 16, 2020. Now, see, this is one reason why I'm upset, because at the end, I didn't get to speak. And you hear here, the first one was set to expire in 2020, but the second one they set to expire in 2000. Wait a minute, let me just go on, because I want to think that through before I speak on it. Okay, so next paragraph. On March 20, 2018, Ms. Becker filed her original objections in the within matter, and she was granted leave to file supplemental objections after completion of the transcripts from the 6 prior days of testimony, which took place before the magistrate. On January 7, 2019, Ms. Becker, through counsel, filed her supplemental objections herein. This matter was originally scheduled for a final objection hearing on January 11, 2019, and all parties were present before the court on that date. However, Ms. Dean requested and was granted a confirmation of the final objection hearing so as to afford her additional time to respond to the supplemental objections filed on behalf of Ms. Becker January 7, 2019. Therefore, the final objection hearing took place on February 27, 2019. A quick note was I had only received from the attorney like 3 days prior their their stuff that I needed to respond to. So I didn't even know what they were trying to appeal for or anything. So that's why it was postponed. Respondent's objections. In her original objections filed March 28, 2018, Ms. Becker alleges that the magistrate's decision was against the manifest weight of the evidence presented at the various evidentiary hearings in this matter. Page 3. Upon conducting a de novo review of the entire record of this proceeding, this court finds, from a preponderance of the credible evidence, that Miss Becker did intend to cause Miss Dean to believe that Miss Becker would cause physical harm to Miss Dean or cause mental distress to her. Further, the court finds that Miss Becker engaged in a pattern of conduct in order to do so and has done so knowingly. In consideration of the foregoing, this branch of Miss Becker's original objection is not well taken. Inter-Supplemental Objections filed January 7th, 2019, Ms. Becker essentially denies cyberbullying, cyberstalking, or any other offensive action on her part likely to cause physical harm or mental distress to Miss Dean. Further, she appears to contend that a reasonable person in Miss Dean's position would not believe that Miss Becker would cause her physical harm or mental distress by virtue of the conduct that Miss Becker engaged in. She does, however, acknowledge that she engaged in behavior which would be considered offensive, especially to ones outside the online forum arenas. Page 3 of Respondent Supplemental Objections. Let me take a quick drink, folks. Upon conducting a de novo review of the entire record of this proceeding, this court finds by a preponderance of the credible evidence that Ms. Becker's actions in this case, which consisted of two or more actions closely related in time, were far more than just offensive. Rather, Miss Becker engaged in a pattern of conduct that knowingly caused Miss Dean to believe that Miss Becker would cause her physical or mental distress. To this end, these branches of Miss Becker's objections are also not well taken. Miss Becker not only challenges the death threat allegations, the butchered pig head allegations, and the butchered pig head is not the wedding photo. I did not submit my wedding photo into evidence. It's in the transcripts that I knew that was Colleen. So that's another lie that's being said over there today. But anyway, the butchered pig head was where this pig had a cleaver, had blood all over it, and my head was butchered and put up on a stick. Okay, I'm going to start this. Miss Becker not only challenges the death threat allegations, the butchered pig head allegations, the hate group allegations, the Social Security fraud allegations. Yes, folks, she went after Social Security. And the threat of murder by horse allegations, which I never claimed murder by horse. I claimed she would murder or kill my horses. She also contends that both of the parties were engaged in, going to page 4, addictive response which escalated over time and the parties continued to interact with each other by the way of social media. While such may be well the cause, as parties' pattern of conduct cannot cross the line of a reasonableness to the content which the responsible party would reasonably believe that they would be in any physical harm or that they could be caused mental distress as a proximate result thereof. In the case at hand, Miss Becker's pattern of conduct crossed the line of reasonableness and constituted menacing by stalking. In consideration of the foregoing, the remaining branches of Miss Becker's supplemental objections are not well taken. Applicable law. In Lewis versus Jacobs, 2013, Ohio 3461, 8/9/2013, the Second District Court of Appeals stated in relevant part, when assessing whether a civil stalking protection order should have been issued pursuant to RC 2903.214, the reviewing court must determine whether the petitioner provided by a preponderance of evidence that the respondent engaged in a conduct constituting menacing by stalking. Menacing by stalking is defined as engaging in the pattern of conduct that knowingly causes another to believe that the offender will cause serious physical harm to the other person or cause mental distress to the other person. RC 2903.211 A1. In order to establish a pattern of conduct, only two or more actions closely related in time are required. RC 2903.211 D1. In determining what constitutes a pattern of conduct, court must take every action of the respondent into consideration, even if some of the actions in isolation do not seem particularly threatening. Middletown versus Jones, 2006, Ohio 3460, 5, 12th District Court of Appeals. Explicit threats are not necessary. Therefore, nonverbal acts directed at the victim may be enough to cause the victim reasonably to believe that physical harm will ensue. State versus Smith, 126, Ohio APP period, 3D 193, 7th District Court of Appeals. A person acts knowingly, regardless of his purpose, when he is aware that his conduct will probably cause a certain result or will probably, going to page 5, be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. RC 2901.22b. The Second District Court of Appeals in Sweet versus Hunt, 2014, Ohio 631, February 21st, 2014, further pointed out in relevant part. Physical harm means any injury, illness, or other psychological impairment, regardless of its gravity or duration. RC 2901.01A3. Mental distress means a mental illness or condition that involves some temporary, substantial incapacity or that would normally require psychiatric treatment, psychological treatment, or other mental health services, whether or not any person requested or received psychiatric treatment, psychological treatment, or other mental health services. RC 2903.211D2. In Sweet, the court further pointed out that the mental distress required for menacing by stalking violation need not always be incapacitating or debilitating. Taylor versus Taylor, 2012, Ohio 6190. The court further stated that it is the duty of the tier of facts to determine whether a victim suffered mental distress as a result of the offender's actions. In making this determination, the trial court may rely on its knowledge and experience in determining whether mental distress has been caused. Upon conducting a de novo review of the entire record of these proceedings, this court does find, by a preponderance of the credible evidence, that Miss Becker engaged in a pattern of conduct that knowingly caused Miss Dean to believe that Miss Becker would cause her physical harm or mental distress. To this end, the objections filed on behalf of Miss Becker are not well taken. Going to page 6. Final judgment entry orders. It is therefore ordered, adjudged, and directed that the respondent's original objections filed March 20th, 2018, as well as her supplemental objections filed January 7th, 2019, shall be and are herewith overruled. It is further ordered that the petition for a civil stalking protection order filed on behalf of the petitioner herein on February 16, 2017 is well taken, and accordingly it is ordered that the final civil stalking order filed in the within matter on March 13, 2018 is approved by this court in its entirety and adopted by this court as its final appealable order. Entry of judgment. Almost there, folks. In accordance with Civil Rule 53D 4, then a lowercase d, this court has undertaken an independent review as to the objective matters set forth herein to ascertain that the magistrate has properly determined the factual issues and appropriately applied applied the law. The court has also undertaken an independent review as to matters which were not objected to herein to determine if there were any errors of law for the issues tried and other defects evidence on the face of the magistrate's decision. In consideration of the foregoing, the court renders that the entry of independent judgment consistent with the order set forth in this document. To this end, it is the court's intention that this document serve as a judgment, as defined in Civil Rule 54, a final order, as defined in ORC 2505.02, and an entry of judgment as set forth in Civil Rule 53D 4 small e. Page 7. Page 7 is a copy of the judge's signatures and tells where all the copies are going to, which went to the petitioner, Rebecca Dean, to Ed Frizzle, which was Brenda's attorney, Springfield Police Department, and Clark County Sheriff's Department. Thank you.